Jamal.
Well, good morning, everyone. Thanks so much for tuning in and sharing a piece of your morning with us. I'm Jamal Rossi. I'm very honored to serve as the Joan and Martin Messinger Dean of the Eastman School of Music, and I have the privilege of welcoming you today. As you probably know, here at Eastman, we are celebrating our centennial, and that's been 100 years of creating and making and learning and sharing music together. And over those last 100 years, so many of our faculty members, students, and alumni have had to navigate this intersection between musical creativity and legally protecting their work. This landscape isn't the same as it was 100 years ago. It isn't the same as it was 10 years ago, and it will continue to evolve and change over the next decade and century. So as we look ahead to the future of education and the future of our profession, I'm thrilled that we are able to offer this virtual session today for all of you across the country. So before I turn it over, I'd like to extend my deepest thanks to our panelists today. I know all of you are going to find their insight and their scholarship and their music and their experiences fascinating. You're going to hear from a number of Eastman faculty members, Christopher Azara, who is a professor in our music teaching and learning department and also an affiliate in our jazz and contemporary media department. Mark Waters, who is the director of our Beale Institute for Film Music and Contemporary Media, and Ari Solotov, who's an entertainment and intellectual property lawyer, who's also a faculty member teaching in the Masters of Music Leadership degree. So to our faculty, thanks so much for giving up some of your time today. We're also thrilled that we're going to have a chance to hear from some really esteemed guests. Joseph Fishman, who's a professor of law at Vanderbilt, and whose scholarship focuses on the relationship of creativity and the creative process as it relates to intellectual property. And Judith Fennell, a musicologist who owns and runs a music consulting firm and who has served as an expert witness, a forensic musicologist on trials involving music copyright and infringement. And I want to extend a very special thank you to Dan McIntosh. Dan is an entertainment lawyer. He is a member of the Eastman National Council, and he is a dear friend. And I'm really thankful for Dan for his creativity in thinking about this and all of his effort to put this together. And finally, I want to thank and introduce Rachel Roberts. Rachel is the director of our Institute for Music Leadership. And truly, anything like this takes a tremendous amount of planning and background work and preparation. And I'm so grateful to Rachel and her team in the IML. So to all of you, I hope you have a wonderful morning and afternoon, and just come away with some new insights and new things to think about. And I'm going to go ahead and turn it over to Rachel. So thanks very much.
Thanks so much, Jamal. It's a pleasure to be here today and to see so many people on the screen, both as panelists and as attendees. As Eastman is celebrating its, sorry, I'm just changing one thing, there we go. As Eastman is celebrating its 100th year, I'm very pleased to share with you that the Institute for Music Leadership is sharing its 25 years of existence. The IML serves students in their development to be leaders both on and off the stage. And we offer a variety of programs. For our students, it's everything from career advising to entrepreneurship advising to classes and to grants for both our students and learners outside of Eastman. We offer grant opportunities. We offer our Eastman Career and Leadership Certificate, and we offer our new fully online MA in Music Leadership degree. If you'd like to learn more about any of these opportunities, please visit us online, iml.esm.rochester.edu, or send me a message anytime. I'd be happy to hear from you and share more if you'd like to get more involved with what we have both at IML and at Eastman. I'm thrilled today to be presenting this online symposium, and thank you, Dan, for everything that you've done. While COVID may have presented many challenges over the last 2 years, I believe one positive benefit is the adaptability and the ease of connecting and bringing people together, especially like those that you will be hearing from today. I'm very appreciative of Dan's work, and I'm excited to hear everyone who will be speaking. And this type of online think tank is something that IML aims to continue in the coming years, especially as we look towards accessibility of our educational programs and serving musicians and learners who are curious about musical leadership and its different components. Today's symposium aims to address the challenges and realities of being a music creator. It's not just for faculty and alums and professionals creating today, but it will hopefully also inform all of us in how we can continue to educate and prepare our music students to make their creative impact in the world. As we navigate through the symposium today, please feel free to type your questions in the Q&A chat box. I'm sitting here next to Dan and we'll help him feed your questions to him. We have specific breaks, Q&A breaks after some of our speakers today. You don't need to wait until that time to ask your questions. So feel free to drop them in the chat, in the Q&A chat, that is, at any point, and I will collect them and be more than happy to facilitate them with all of our speakers. Thanks again for tuning in, and I'd like to turn things over to you, Dan.
Thank you, Rachel. I'm delighted to have all of the participants here today, and thank you again for agreeing to give this time to this subject matter. I practiced law for 40 years in Los Angeles, and when I stopped practicing law, I decided with my wife to move to Rochester specifically because of the Eastman School of Music. I am a music fan of many genres and live almost next door to the Eastman School of Music, where opportunities for hearing live music are extraordinary. It got a little bit dicey during the pandemic, but things were streamed. And now we're actually even back to being able to hear music live. I also got an opportunity to do some adjunct teaching in the class of my friend Mark Waters, who you will hear from, on the legal and business side of the music industry. How do you make a living as a musician and as a composer? How can you protect what you create? How can you avoid having other people say you've stolen things from them? So today's program is a real opportunity, which I welcome, to pursue some of the aspects of that, and particularly hear from people who are involved in the various sides of this: creating music, teaching music, lawyering, everyday issues that are presented when you represent artists, musical artists, and scholars like Joe Fishman, and experts like Judith Fennell, to whom people turn when the question of what does constitute infringement, what's okay, what's not okay, because that turns out to be a difficult task for lawyers, judges, and juries especially to navigate. So we will be looking specifically at how can the balance be properly set and maintained between freedom of creation, the First Amendment right, and protection of what it is that you create. And one of the interesting things to me is that there's three real significant players in this this ongoing conversation. One is the public, because the copyright clause in the Constitution, which grants to Congress the right to enact laws for the protection of science and promotion, actually, of science and, quote, the useful arts, which fortunately music, it's agreed, comes within. The Congress has the power to enact laws, and it has. And the dual purposes that it tries to serve are both protecting creative intellectual property and promoting more intellectual property creation. And there's a balance, obviously, that has to be struck. So we're going to begin our program with insights and perceptions and demonstrations by Christopher Azara, who you've heard is a professor of music at Eastman. I've heard him speak on a number of occasions about the creative process, and it seemed to me this was the appropriate place to begin. So Chris, let me turn it over to you now. Please proceed.
Well, that's terrific. Thanks so much, Dan. And like Dan, I moved to Rochester because of the Eastman School of Music. This is a place that I have a lot of enthusiasm about, as I think we all do. And I really appreciate and I want to thank Dan and everybody for inviting me to do this, because it's an important topic and it's really nice that we're starting things off with a little music. The interactions I've had with Dan focus around my energy and enthusiasm around how we learn to improvise, how we have situations where creativity can be more central, a big central part of the teaching and learning process. So much of what I'll say to you today is directly related to the conversations we want to have about this. Primarily what I thought I would do is introduce you to some musical ideas so we can directly get to some understanding of how this sort of works and how we learn to do this. And then that would lay a foundation and set the table for our further conversation. So what I think I'll do is give you a sense of things by sharing my screen. That way, there's a way for you to hold on to some of the ideas I'm presenting. Very simple slide I'll show you. So I'm going to go to share screen and click here. And I'm wondering if you can see my screen. Does everybody see that okay?
Yes, Chris.
All right. That's great. So as I'm working with folks that are involved in this creative process, what we're really thinking about is how we can learn to improvise and compose and arrange music and tell stories while we're doing that. And so to learn to do this, and as you start to get into the details of the things that we're going to be discussing today, the idea of telling a story is a priority for creators. And we do that by learning lots of repertoire. And that repertoire inspires us to include our understanding of that repertoire and then transcend it with our creativity. It's from that repertoire that we learn chord progressions and patterns of rhythm and articulation and style. And you might think of that as vocabulary for what you're expressing. And we have, as musicians, this opportunity to express ourselves from within. This idea that there are some things better said with music. And for many of us, music is that place where we can share our ideas. I always try to refer to what we're doing as a expression of our mind, body, and spirit in a way that taps into something that comes from within. As a part of that, musicians have developed skills and do have a discipline around the reasoning around how this musical syntax might work. And while we're dealing with that, we might think about, well, how is this happening from a standpoint of the ways that folks have expressed music as folks are engaging in that, and how can I contribute to that? So that reflection happens through composition and when you read, because when you read and write music, you have the ability to time travel. You can go back in time and investigate something. You can go forward in time. As a composer, you can write something and then say, hey, maybe I'll revise the beginning of this to reflect more of my thinking now. That reflection process is necessary. And musicians have exemplars in their lives that are inspiring them along the way. So you might learn to improvise a solo. You might take a particular song and you might have that in mind as you're writing your song. This is very common among creators. So that model right there is a common way to maybe put your head around what the foundation might be for what we're doing. And we're expressing these ideas through speaking and composition, and we're understanding these ideas. The input part is the listening and the reading. The output part would be the improvising and the writing. So let's take a piece of music, for example, and think about how this might work specifically. So we're taking a piece of repertoire as an example so that we can understand all the things that might happen in the creation of a work and the performance of a work. And the idea would be to include and transcend that understanding. And the transcending part is our creativity. So you take a very simple tune like Simple Gifts, which is popular. Aaron Copland has Simple Gifts as the foundation for a tune that he composed. And the piece of music is called Appalachian Spring. And you want to expand, when I use a word like tune, it's sort of slang for me to represent all kinds of music. So you'll notice that I'm going to reference everybody from Aaron Copland to Miles Davis to Duke Ellington to some popular musician of now like Beyonce or somebody, because they're all kind of navigating some similar ways of unfolding their musical ideas. So if you look at a tune like Simple Gifts and you think about the harmony of Simple Gifts, there's an underlying structure that you might think of as a pendular structure, where you have this one sound and this other sound and a sound like this. So if you look at that tree, you can notice that everything comes back to this sound. That's the bottom of the tree. And then there's a little pendulum that goes do, do, do. Some of you might be familiar with referring to that as do, so, do. If you zoom in a little bit more, you see how these patterns of do, mi, so, re, ti, so are present in the melody. So that idea of da, dee, da, 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 da. If you zoom out of that, you get this. And if you zoom out of the other part of the song, you get. And that's a foundation for a lot of music. The style of the music could be something like or in the sense of Simple Gifts, you might have something like. So you get the idea that that's a foundation for any music that's in major. And major is a term that we use to describe the overall feeling of a piece of music that has these qualities of harmony. You can feel some kind of resolution and some kind of what we refer to as tension, and that likes to go back to this one. The way to think of this maybe is that notes are either in motion or at rest. And the same thing is true for rhythm. We have a tree of the rhythm. You have larger beats that you'll hear people perform, and you'll hear the smaller beats. So you have ba, ba, ba kind of beats. You have ba, 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 ba. You have ba, 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 and then you hear the song. And all of that is happening rhythmically as we express ourselves with dynamics and articulations and phrasing. If you look at this slide, that's Aaron Copland sketching out. You see how I refer to it as a tune because he loved this tune. He wrote, "Shaker melody, 'tis the gift to be simple." Well, this turns into the larger scale work of Appalachian Spring, the orchestral work. So that sort of gives you an idea of a simple, what I would call pendular tune. If you expand upon that, the same thing could be said for a song, the New Orleans tune, "When the Saints Go Marching In," which we're all probably familiar with. You hear how that same pendulum is happening hear that? It goes to here, then back. Oh, here's a new idea. And then can you feel how that might lead us back to here? Now, the second half of this tune is a very common progression. There are many of these harmonic progressions that musicians learn, and they serve as models for harmony. In fact, the Italians in the Baroque called them partimenti. This particular part of the song, the second half of this song, actually has an Italian name. I'll show you some of these Italian names. It's called the passamezzo moderno. It's when you go from a 1 chord to a 4 chord, back to a 1 chord, to a 5 chord, back to a 1 chord. Now, when I'm referring to these numbers or this solfege, I'll show you a picture of my keyboard here real quick and give you a sense of that. So if you look at the video of the keyboard, right? So you've got there's what we might call do or 1. Go up, that's 4, we might call that fa. Here's so, and here's do. So this chord progression of going from do to fa, to do, to so, to do, is very common. It could be in a Bach piece. You could have, right? That comes from a chorale. It could be a blues. And it's going to go to a 4 chord right here. And then it goes to the 5 chord here. So the blues is based on a harmonic progression that's been around for hundreds and hundreds and hundreds of years. So give you an idea about how these work, the other kinds of progressions you might think of are the Romanesca. The Romanesca is very popular. The Beatles use it in I Want to Hold Your Hand. If we do it in this key. Oh yeah, I tell you something. I think you'll understand. That's a progression that's been around for hundreds of years. It's the same progression in the song Greensleeves. You hear how these all connect. There's a harmonic progression called the rule of the octave, which Bach uses in the first prelude. And the progression of that tune is sort of a whole idea of, if you want to learn what the rule of the octave is, learn that first prelude. And musicians use that chord progression to be creative. Charlie Parker uses that chord progression in a blues that he wrote called Blues for Alice. It's the same chord progression. Chance the Rapper has a tune with the rule of the octave. Paul McCartney wrote the tune Yesterday. That's based on the rule of the octave. And the rule of the octave is essentially, for those of you who understand notation here, it's essentially a harmonic progression that goes. Now, of course, pieces are longer than 8 measures long, so musicians will linger on the first couple of chords, and then they move into the next. And that's how you get in a more lengthy, elaborate piece. In fact, sonata form, one of the forms that you study if you're learning about symphonies or piano sonatas, there's something called sonata form, and it's based on these 8 chords in terms of how it gets expanded into a large-scale work. So if I'm playing a blues, or if I'm playing something that Bach wrote, if I'm playing a piece by Bruno Mars or something, some of the songs that we're going to be discussing today, all of this comes from the harmonic and rhythmic models that have been around for centuries. And what I've tried to do in my time here is to provide you with a context for what that feels like musically in various styles. So one of the things that we want to do as creative musicians is learn these harmonic paradigms, these rhythmic ideas. For example, in jazz, there's a feeling where you have an emphasis like this, right? So if you're playing a piece in the style of a jazz piece, it would have a sort of a beat like that. If you play something from South America that has a clave rhythm, so you have this clave, ba, da, 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 that's pervasive in all of that music. You might have an Alberti bass for a classical piece, like. That kind of thing. And I was just improvising that because that's a common vocabulary of a Mozart or a Haydn kind of vocabulary. If I'm improvising this, it's the same kind of thing that we have these models about where the notes like to go, much like in language, where you feel the next word I'm going to say. If you happen to see I did a TED Talk in Rochester here, and I talk about how one of the most fundamental things we can do is understand music in such a way where we have an anticipation and an expression and an understanding of how the poetry of the music unfolds, much like my language is unfolding. And so in music, you can even, as simple as this, and then you might anticipate that next. And again, that's another harmonic paradigm, just 1 and 5 in minor. So I hope that gives you somewhat of an overview. I may have created a situation where you have some questions, but that's not a bad thing. I'm hoping that what I did anyway was introduce something in a musical way so that when we're having these conversations, we can refer back to some of these ideas.
Thanks, Chris. And would you mind stopping your screen share when you have a moment?
Yeah, thanks for reminding me. So I go here and I say, stop the share, right? And are we good now?
We are good. Thank you so much, Chris.
Okay. Is there any reason for, Rachel, is there any reason for any questions or anything, or do you want to wait for that, or how do you think that might work?
Yeah, I think let's wait. Let's hear from Joe, and then we'll have a moment for Q&A after he's finished as well.
Great. I'm hoping that what I presented was somewhat clear and hopefully an inspiration for our conversation.
Great.
Well, you're a clear illustration of the power of Rochester to attract people like me who love music and who get a chance to understand or at least be introduced to some of the basics of how music is created. And that's why I wanted to start with you, Chris. Thank you again. Our next speaker is going to be Joseph Fishman, and then we will have a question period where you can be, as Rachel said, submitting questions as an audience member as we go along. And then we'll have a period of time where we will address those questions. I thought grouping together Chris and Joseph would be useful because Joseph's going to talk about how the law looks at all of this and tries to interpret the Copyright Act. So just a few things about Chris. He is, as you probably know, if you've read the bio that was provided to you, a professor of law at Vanderbilt Law School in Nashville, in the heart of Music City, USA. His focus is on intellectual property and creativity. And two of the courses I noted that he offers made me want to move to Nashville. Music and Copyright Seminar, and a course called Music Law. It's hard to think of anything that could be closer to what we were interested in here. He has a master's in musicology from Cambridge, a graduate of Harvard and Harvard Law School. Let me introduce now Joseph Fishman to talk about how the law looks at music and creativity and plagiarism. Joe?
Thank you very much. So this is a treat for me. Before going to law school and then becoming a lawyer and becoming a law professor eventually, I studied musicology. I was in grad school for musicology at one point. So this is a big nostalgia trip for me to participate in an event like this. And there's a lot about the previous discussion that Chris was leading that I really miss. So thank you so much for including me in this. I am going to share my screen now. So hopefully you can see the image that I am looking at. But let me start by saying it feels like every couple of weeks there's a new lawsuit against a high-profile musician for committing copyright infringement. Somebody else wrote an earlier song. That song sounds something like the current one, and is it too similar? Right? That's the question. So here in the United States, the latest allegation, or two, in fact, has been against the artist Dua Lipa. That's from only within the last month. And in the UK, I can sneak this in here as of this morning. There was a judge that decided literally a few hours ago that Ed Sheeran had not infringed someone else's copyright in his song Shape of You. These are, or the Ed Sheeran case and perhaps the Dua Lipa one, we'll see where that goes, but those are attempts to get in front of a jury. Many of these cases settle before a jury or a judge ever gets to decide anything definitively. Sometimes it does go all the way to the jury, as with Ed Sheeran and the, I would say the most famous three recent cases involving Robin Thicke and Pharrell Williams, Led Zeppelin, and Katy Perry. I'll say a couple of words about those cases in just a bit. But over the last, I would say 5 years, there's been this narrative building up that these cases are making songwriters afraid, that it's too easy to get sued for making a similar song. More recently, within the last year, there's been this counter narrative that the pendulum may be swinging back in the other direction. And some courts have been reasserting themselves as gatekeepers who can dismiss a case without a need for a jury at all. And that's fueling a sense that maybe it's not so easy to sue songwriters for infringement after all. So here's a quote from that New York Times article that I had up on the screen a moment ago, where a lawyer for Katy Perry, in that case that she ended up ultimately winning, said the blurred lines curse, its chilling effect has been lifted. And we have with us, we're very lucky to have with us Judith Fennell, who was on the front lines in that case as the expert for the winning side. So I'm sure she'll let us know whether there really is a curse here or not. But so that is how it's being described in the media. So I mentioned Katy Perry won that case. Within the last month, the Ninth Circuit Court of Appeals, which I would say is the most influential federal appeals court in the country for copyright issues, affirmed a trial court's decision to throw out the jury verdict against Katy Perry. In the appeals court's view, the claim was just so weak that no reasonable jury could say it counted as infringement, even though an actual jury had already said it did count as infringement. Meanwhile, you have other brand name artists that are trying to just avoid litigation altogether by prophylactically giving songwriting credits to predecessors when they are criticized or they're worried that they sound too much alike. So Olivia Rodrigo recently did this with Paramore. A few years ago, Mark Ronson did this when he was accused of ripping off the Gap Band when he wrote Uptown Funk. So this is what's going on. This is what you might be reading about in the papers if you follow this kind of stuff. What's the law behind all of it? How do we know what counts as infringement versus routine, uncontroversial musical borrowing and influence that happens all the time and that the law doesn't care about? Well, I'll give you a whirlwind tour of how US law approaches that question. I can't give you a definitive summary of how the US law answers that question because often the answer is pretty fuzzy, but I'll tell you how it approaches the question. So copyright is exclusively federal law. It's not state law. And both the rights and the limitations on those rights are set out in a statute called the Copyright Act. But they're also heavily, heavily supplemented by decades of judge-made law. So if you were to look just at the statute, you'd be missing a lot. Musical works, as you can see here in section 102A of that act, are among several different categories of authorial expression that are eligible for copyright. And it's important to distinguish here between the two categories that I have highlighted. So you have the underlying musical work on the one hand, and any sound recording that embodies that musical work on the other. Each is its own category. Each can receive its own copyright. So if I were to pick, for example, Dvorak's Seventh Symphony, which was written in the 19th century, that the musical work, the composition is in the public domain, but a contemporary recording of that composition is most likely still under copyright. So when somebody uses bits and pieces of another's sound recording, that's called sampling. It's not really going to be my focus here. I'm primarily going to be talking about accusations that someone is infringing the underlying musical composition rather than any particular recording of that composition. So to get a copyright, you don't need to do much. You do not need to apply to the government the way you would for a patent on a technological invention. You don't need to mail it to yourself, if you've ever heard that folk myth. All you need is something that is sufficiently original, and that's a low bar, and then to fix that expression in some kind of tangible medium. That could be writing notes on paper, it could be recording something to a computer hard drive, but once you have original material that's been recorded somehow, that's it, you're done, you have a copyright. So let's assume that someone has a valid copyright in a musical work, and that person discovers another song that sounds suspiciously alike, and they decide, I want to bring a lawsuit over this. What would a court be asking in order to determine if that similarity constitutes infringement? So broadly speaking, it's a two-part inquiry. The first question a court would ask is historical. It's trying to figure out what happened factually in the past. Did the accused infringer actually copy from the copyrighted work? Or did they instead come up with it independently, or even copy from an unrelated third-party source? That's not a normative question. There's no like value judgment baked into that. We're just trying to figure out what happened in the past. Did copying occur or not? The same way in a tort case, we might be trying to figure out, well, when the car went through the intersection, was the light red or green? Here we're trying to figure out, did the accused copyist actually copy anything? Because no matter how similar two songs are, if the second comer came up with the material independently, that is a complete defense. Copyright only covers copying. It doesn't touch somebody else's independent creation of the same material. Rarely do you have direct evidence of the copying occurring, like somebody outright admitting it. So instead, it's usually proven forensically by showing some baseline level of similarity, and that the accused infringer had some access to the earlier work in order to make the copying happen. And often that's done with the aid of expert witnesses. The second step, in contrast to the first, is a complete value judgment. Once the court thinks that the accused infringer may have indeed copied something, a court would then ask if that copying is wrongful. Did the copied material include the copyright owner's original expression? Is there something protectable included within the stuff that was copied? And that standard, which is the linchpin to all of these court cases, is summed up as whether the two works are substantially similar to each other. And that question is supposed to be answered from the vantage point of what the average lay listener would think. The guidance that we have about what's substantially similar and what's not is pretty malleable. So there's a lot more I could say about this point, but I'll give you a taste of it. On the one hand, in the recent Led Zeppelin case that the Ninth Circuit decided did not constitute infringement, the court emphasized that you don't get to claim ownership over anything too commonplace, something that we could call a musical building block. So the court said copyright does require at least a modicum of creativity and does not protect every aspect of a work. Ideas, concepts, and common elements are excluded, nor does copyright extend to common or trite musical elements or commonplace elements that are firmly rooted in the genre's tradition. These building blocks belong in the public domain and cannot be exclusively appropriated by any particular author. On the other hand, a very influential case involving Mariah Carey also emphasized that there's no blueprint for determining what counts as substantial. The court there said, and it's the same court, same Ninth Circuit Court of Appeals, in analyzing musical compositions, we have never announced a uniform set of factors to be used. There is no one magical combination of these factors that will automatically substantiate a musical infringement suit. Each allegation of infringement will be unique, so long as the plaintiff can demonstrate through expert testimony that addresses some or all of these elements and supports its employment of them that the similarity was substantial and to protected elements of the copyrighted work, the test is satisfied. And within those parts that I put in ellipses there, the court rattled through all the different pieces of a musical work, melody, rhythm, tempo, structure, orchestration, all of these different permutations of musical elements that could support an infringement claim. So this is a very flexible way of thinking about what constitutes infringement, but with that flexibility comes potentially a lack of predictability. When the blurred lines infringement decision occurred in 2015, the winning theory of substantial similarity was based on what the expert in that case, Judith, and then the court adopted as a constellation of multiple different overlapping elements over the course of the entire song. And a lot of observers were shocked that you could have an infringement claim that could succeed based on something other than melody and lyrics. So Judith will be talking about that case from her own personal experience. For now, I just want to emphasize the amount of surprise that there was. And since we're being hosted by a music school, I will focus on music school reactions, but we had somebody from the USC School of Music saying the ruling appears to go beyond the elements of a song that may be a copyright, primarily melodies and lyrics, that extends to tempo, feel, and instrumentation. You had someone from Berklee College of Music. Over the past 100 years, basically the melody and lyrics have been the things that are really protected. You had Joanna Demers, a musicology professor at USC. This verdict is representing a sea change in terms of how copyright law has been interpreted. The way that the law has been interpreted in court for the past century until this verdict has privileged only two elements as being deserving of protection: the melody and the lyrics, if there are lyrics to the composition to begin with. And they have a point up until recently. Melody was indeed the primary focus of music infringement cases at the expense of other elements of a composition like harmony or orchestration. You can go back to the mid-19th century in the United States, borrowing from similar precedent in England, and the cases were all about melody. So why is that? And before we get to how things have changed since, why is that? So one big reason is a persistent cultural norm that melody is aesthetically, it's the heart of the work, right? It's what gives the work its identity, going back to 19th century European art music. And in the United States, that proposition traces back to a British decision called Dalmain v. Boosey. In that case, a music publisher had rearranged a bunch of serious arias from Albert's opera Lestock and turned them into light dance music. And the publisher was sued over this, and the publisher argued, well, this is a fair abridgment. I'm allowed to do this under, in England, a permissive standard for non-literal copying called fair abridgment. But the court said, no, this doesn't count. Why doesn't it count? Because you retained the melody. You changed other stuff, but the melody was constant. And it is the air or melody which is the invention of the author and which may in such cases be the subject of piracy. Melody is that in which the whole meritorious part of the invention consists. The original aria requires the aid of genius for its construction, but a mere mechanic in music can make the adaptation or accompaniment. And that attitude was all over aesthetic views in 19th century Europe. So Jean-Jacques Rousseau, who wrote prolifically about music theory, described melody as the soul of music. I can put in a lot more examples here. In the interest of time, I will not, but I will skip ahead a couple centuries to the 20th century US law. Right? Richard Wagner said it too. Music's only form is melody. So there was a case in 1952 where a judge in New York said that originality of rhythm is a rarity, if not an impossibility. Harmony, we all know harmony is a bunch of rules, and therefore it's in the public domain. It's in the melody of the composition or the arrangement of notes or tones that originality must be found. It is the arrangement or succession of musical notes which are the fingerprints of the composition and establish its identity. I'm not sure if that's ever really been true, but it's certainly not true of a lot of music that's been produced over the last century and a lot of music that's being produced today. I don't know if this accurately describes jazz, if it accurately describes hip hop, if it accurately describes a lot of 20th century art music, even today's top 40 music, the kind of stuff that is usually sued over in copyright litigation, isn't obviously primarily about the melody all the time. The production matters a huge deal to a lot of these songs. So the traditional justification for privileging melody is pretty weak. And so to me, it's no surprise when cases like Blurred Lines comes along, a court doesn't think, well, I have to dismiss this case unless everything is about the tune. And today, not just in that case, but in many cases, courts don't just limit the analysis to melodic infringement the way they used to. And there's a trade-off in that switch. On the one hand, the law is working with a much richer definition of what a musical work is, instead of the artificially narrow myth that it's always just about the tune. And I think that's a good thing. On the other hand, though, it becomes a lot harder to predict what's infringing and what's not if you need to keep track of multiple possible points of similarity instead of just one. So US law has ended up with a more accurate definition of what a musical work is and what makes it work, but a lot less predictability in the system. And my own view, which I'll close with here, is that we would be better off moving back to that earlier melody-focused regime, just not because melody is always the heart of every musical work, it's not, but instead because it just makes everything so much more predictable. And I think music is modular in a way that not every kind of authorial expression is. And so it's often relatively easy for composers to identify some discrete chunk of a work called the melody and focus on that as a thing to avoid copying. And if you're trying to figure out how close you can get to an existing work, that means you don't have to play this really hard game of trying to figure out some kind of overall index of similarity and then assigning weights to the similarity between melodies, similarity between harmonies, similarity between instrumentation, and shaking them all up and trying to get an answer at the end of the day of what's too similar and what's not. All you need to know is don't copy the melody. And I think that would help downstream creativity if we were still working that way. We're not. I don't mean to suggest that this would be a bright line inquiry where you could say, okay, just don't copy 5 notes or 6 notes or 7 notes, right? There's no number of notes that we could give guidelines as to how many you can copy, but at least we would know that we're focusing on a melodic sequence, which would cabin the inquiry somewhat. So that's where I would like to see things going. But we have moved away from the days, just descriptively, we've moved away from the days where melody was the only thing that counts. I will stop there.
Over here.
Start again. Yep.
We're going to move to a brief question period so that we can address questions that have come in from the audience, particularly regarding Chris's presentation and Joe's presentation. I have a question, and in the meantime, I'd like to ask, I'll ask it of Joe, but it really relates also to what Chris was saying. With popular music, and I think in other genres, it's clear that certain kinds of rhythmic patterns coupled with harmony and call it melody overlay can become what is sometimes called a hook for music. And I'm thinking particularly of a song that was done by Queen many years ago called Under Pressure. And Queen ended up suing another band, I forget which one it was, but it was basically over, I think, the issue of whether that hook, which was not a melody, it was something that could be copyrighted and should be protected. So I think probably Chris would be a liberal about that and say, well, that's pretty common. But what do you say, Joe?
So if we're thinking of the same thing, it was the bass line
Yep.
in Under Pressure,
Yep.
which Vanilla Ice famously defended himself on camera by saying, one is da da dum ba ba dum bum, and the other is bum 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 ba da dum bum. Right, he added in like one like upbeat or something there. So bracketing for a second how commonplace that is, and I'll return to its commonality in a second. I'm agnostic as to whether a melodic line occurs in the vocals or in an instrument, right? If that sequence of pitches and their rhythmic duration is in the bass line, and that's a notable part of the song, I'm fine with that supporting an infringement claim if the other bass line is similar enough to it. So when I talk about melody, I don't just mean the top line vocal melody. So I should clarify that. But then, in that case, I would want to know how common really was that kind of bass line, right? Harmonically, sitting here doesn't seem particularly notable to me. So was there something about that rhythmic duration of those two notes in that sequence that made it special? If not, I think it's such a short unit of music, right? We're not talking, unlike in Blurred Lines, which was really about the whole song, right? And to give credit where it's due, right? The Katy Perry case I talked about was about a little snippet. The Led Zeppelin song that I talked about was about a little snippet. The Blurred Lines case, that was about the whole song. So if we're talking about just that snippet of the bass line in Under Pressure, even as notable as that snippet is, that to me would be a big thumb on the scale against it being making the two pieces substantially similar to each other.
Okay. Chris, any thoughts?
Yes, it's interesting that Joseph was making some comments. I was thinking, because as Joseph was speaking, and he just said this, if you think of all parts of music as melodies, even the bass line is potentially a melody. If you think contrapuntally, that's kind of a word we use as musicians to talk about how all the lines, you could use the word line, or all the musical ideas are interacting with each other. And so you'd have to ask the question is, how specifically similar is what they've done when you combine the harmonic structure with the rhythmic reuse of material? Does that become the same or not? And that's the distinction one has to make. The idea is that throughout history, harmonic structures are present, and the creator either works within the paradigm or breaks the rule to do something, different. Or sort of, oh, what if I play with it this way? And that might be considered something, that's really interesting. Or you're somebody who culminates an idea and says, this is a harmonic paradigm, and I'm going to be the best at this. And so I think that's the level of detail that should be discussed. That, for example, with Blurred Lines, it's just a pendular song. It just goes back and forth with the same chords. And the Marvin Gaye song actually has a lot more decoration in the harmony. And what I took away from that case it was the production. It was the vibe of the production, which is a somewhat unique current issue that we have, somewhat, because it does the vibe of it, the production of it is something. But as far as the harmony, the rhythm, the melodies, you can make a case that they are different, and I think that's what the controversy is. But getting back to what you said about any hooks or anything, I think what would have to happen is there'd have to be a conversation around how any melodic shape, whether it's in the bass or what we call an inner voice, or as Joseph said, the top line, if you will. But the melody sometimes can be the more prominent focus can be in the middle with decorations around it. It's more a question of where do we get to that level of detail where it is exactly the same or enough the same, because there's a level of all music where you could compare lots of songs that are unique in their own right. But if you zoom out far enough to the structural part, they're the same. So it's just an interesting conversation. I like to call it, when I teach my students, I like to call it zooming in and out. There's so many songs that do the same thing, but they're different songs. It's just an interesting conversation I'd like to have with various pieces of music along those ways. And I think what Joseph just said is, how much level of detail do you want to get to before you're saying, there's a problem? So anyway, something to think about.
Great, go ahead.
We have a question from the audience, which is addressed to Joe. Could you talk a bit about educational fair use in the context of copyright infringement?
Yeah.
So that is an event unto itself, right? That's a big topic, but fair use is assessed through 4 factors, and one of them is, what is the nature of the use? And if you are making an educational use of it, that would weigh in favor of fair use. If you are commenting on the work that you are displaying or playing or reproducing, right, that is another point in favor of fair use. So we're going to be hearing in the course of this event, for example, I assume snippets of sound recordings related to some of these disputes that have been going on. Fair use, right? If as long as you're not playing an entire album and just kind of like letting it play, right, that is a very strong fair use case. But one of the other factors, and I'll leave it here because I don't want to answer this for too long. One of the other factors is, are you using too much? So even if it's an educational purpose, the amount of the material that you use needs to be reasonable in relation to your educational purpose in using it. So that could be the entire work. And if we were talking about paintings, right, and you needed to show the whole painting to understand what it is, so go ahead, show the whole painting. But you don't, if we were talking about a book and we were only cared about a particular passage from the book, that wouldn't necessarily give you license to copy an entire book and distribute it. So it's an unfortunately truncated answer to what is a pretty large question, but that's as much as I can say, in a minute.
And Joseph, is it? It's my understanding that the educational rights and the, I would say maybe the commercial rights might be owned by different people, correct?
When you say the educational rights, I'm not sure I know.
So for example, the Beatles music is, one company might profit from that and the commercial rights are somebody else, or there might be different folks benefiting from the sales of that, or
it's certainly possible, and certainly happens, that you have different entities that own different or own the right to exploit different markets when it comes to music. That could be the publishing on the one hand versus the recording on the other. But if it's a fair use, like in the context of educational uses, that means definitionally there's no licensing market. That needs to be there, right? No money needs to exchange hands in order for the use to occur.
For the fair use part, right?
For the fair use, right?
Yeah, I was just curious about the other part of it where Hal Leonard might own the rights to something for educational arrangements of it, but somebody else owns the rights for the Grammy Awards or something.
Right. So that's possible. Yes.
Okay, but that's not fair use. I'm sorry to blur the waters there, but I just was curious about that.
Right. So I mean, there are licensing agents that, right, if you want to use something in the classroom that's not a fair use, or you are worried it might not be a fair use and you don't want to take the risk, right?
Yeah.
There are licensing markets for that.
Yeah,
and it's possible that those are owned by different entities.
Okay, yeah, thank you.
Ari, do you have any thoughts on this?
Yeah, well, Joe said it perfectly, which is that Sony ATV, or Sony Music Publishing now, which holds many of the rights, for example, to the Beatles catalog, may sub-license certain rights to groups like Hal Leonard or Alfred, to either for print rights or print reproduction or for educational uses or even arrangement uses. So the copyright holder may decide to sort of filter out those rights because there may be other agents who are just do a better job of representing those rights in a particular market, all for the purpose of generating money for the copyright holder, being the publisher and the songwriters who benefit from royalties generated from those licenses. So that's one thing. The other thing I would mention is that, and we'll come back to this, fair use, it's essentially a defense to copyright infringement. So it's sort of like acknowledging that you are in fact infringing the copyright, but you actually have a good defense under law to do so. And so the point being that the law provides these exceptions, but because there are exceptions, there's no bright line rule, as Joe pointed out. So
okay, let's move on, if we could, to Mark Waters, who's our next speaker. Mark, I've known since I arrived in Rochester in 2017. He arrived about the same time when he was appointed the director of the Beale Institute of Film Music and Media. I always forget the other one, Mark. Mark has had a long career as a composer. He's a graduate of USC Thornton School, an instrumentalist initially, and still a saxophone player. But he's gone on to compose for many films and television productions, also for the Olympics. He was the composer of the, I believe, both opening and closing musical themes for the Olympics in Atlanta and in Salt Lake City. He conducts and has conducted a number of philharmonic orchestras. And as a baritone saxophone player, he has composed and I believe recorded himself a symphony concerto, I guess we would call it, for baritone saxophone, one of my own favorite instruments. So Mark is going to talk about the practical world of being a composer and negotiating the quirks and obstacles that exist for somebody who wants to create music and who has been hired, particularly by corporate employers to produce music, and at the same time needs to negotiate around rights that might exist by reason of existing music. So Mark, please proceed.
Great. So delighted to be here. Thank you, Dan. Thank you, Rachel. It's been fascinating hearing Chris and Joseph talk about this. It really is such an important part of the creative process of being creative and being original. And in the world of media, which is essentially TV, film, and video games, it's kind of surprising that we don't have more lawsuits because of the way that a composer is directed by the people that he or she is working for. How do they tell the composer what it is they want? In the old days, before there were temp scores, it was a composer and a director or a producer had to be very good with their adjectives. We want it scary. We want it happy. We want it sad. We want it funny. And of course, these are very broad headings, and a multitude of different scores could come from that. So a composer has to be very good at intuition, asking questions, basically trying to be a mind reader, so to speak, as to what the employer wants from this, because essentially we are a hired gun to basically provide a product, very specific product for a very specific need. In later years, a thing called the temp score came about, and depending on what generation you were part of, it was either the a clear improvement on how to communicate, or it was the bane of our existence. It started coming about when I was first starting to get work, and this was in the early or late 80s, early 90s when my career started. And you would hear of stories of from certain composers who were of a generation or two before me who said they never want to hear the temp score. They never want to be pushed in a certain way, because they said, then I become a duplicator and not a creator. I was much more, I suppose it was because I was more hungry to get work and more anxious to get my career started. I was happy to hear what the director wanted. I'd much prefer that than to have, and one time I did work for a director who fashioned himself as a composer, and that was nightmarish. I much prefer to have a, well, we want it to sound like this piece of music. And there are music editors whose whole career is they put together temp scores, and they have a massive library of music and scores and classical pieces and songs, and they put together temp scores that are bounced back and forth to the director before the composer is even brought into the, sometimes before it's even brought into the hiring phase. And this score then is sometimes used in test screenings, and the editors are using it to cut to, and so by the time the composer comes on, the filmmaker has probably heard this particular temp score yet dozens and dozens, if not more times. So imagine if you were to see a movie several times, and we've all had those favorite movies of ours that we've seen multiple times. Let's just say Patton or Ben-Hur or Star Wars. And then you suddenly heard it with a completely different score. It could be a great score. It could be a fine score, but it's not the one you're used to. And there's this, what we call temp score-itis, that a filmmaker can get locked into being, just used to. And it's very understandable. I would not fault anybody from that. And it's a very much a part of being a successful media composer, that you have to be able to navigate this process. Books have been written about how Star Wars was originally temped with classical music, and George Lucas initially thought it would be very effective to have classical music be the score for it. It had been used rather questionably, but ultimately history has said it was successful. In 2001, the use of standard existing classical music. I happen to think that it was not as effective, and that the original score that was written by Alex North would have been much more effective. But history has accepted that score as being the one that we associate with 2001. So when John Williams started to write the score for Star Wars, he was given a very specific temp score to work against. And he wisely, and fortunately for all of us, was able to convince George Lucas that an original score was the only way to go. In spite of the fact that the film was created with a great homage to the old swashbuckling heroic movies of the 30s and 40s, the score could certainly be influenced by those, but that it needed an original score. Now, how original was it? Well, I thought I would share one example of where I think, and there was no lawsuit on this. It's rather surprising that there wasn't. And I happen to think that there is no bigger fan of John Williams on the planet than I am. He's the and this score, the Star Wars score, was really the beginning of my career as far as inspiring me to pursue this. But I will share the screen, and let me just make these adjustments there. I've put together a, I'm sure a lot of you will recognize this is a scene from the first, what I consider the first Star Wars. I think now it's called the fourth one. But the original 1977 Star Wars, where the two droids are in the desert. And I'll play you John's music for it, and it will slowly crossfade into Stravinsky's Rite of Spring. And you will see it's clear that the temp score was this particular piece of Stravinsky, and how far should a composer go to differentiate from it. So that's the Stravinsky, and this is what John wrote.
Malfunctioning little twerp. This is all his fault. He tricked me into going this way, but he'll do no better. Wait, what's that? A transport! I'm saved! Over here! Hey! Hey! Help! Please help!
So it was interesting hearing Joseph talk about how if a piece of music is, if it's proven that it was purely natural, that the piece of the piece in question came about natural and without specific desire to exploit a previous piece, that it's considered acceptable. I would think that in cases such as this, if it is proven that the original piece was used in a temp score, that it was clear that the composer was told to emulate however much of the quality of the piece, that it can set themselves up for a problem. Here is another example of a similar situation. Let me bring up the proper video here. I forget what year Gladiator came out, but it features a very effective score by Hans Zimmer, who just a week ago won the Academy Award for his wonderful score to Dune. In this opening battle of Gladiator, it is clear that Hans was listening to the first movement of Gustav Holst's The Planets. And even in an interview where he was talking about how he came up with the score, acknowledged the spirit, and I forget the exact wording, but he said clearly, I was influenced by Gustav Holst. I think mistakenly not knowing that this piece was not in the public domain yet. And he was sued by the estate of Gustav Holst. And I will play you now this piece, and this will, I'll play you the scene starting with Hans's music, and it will slowly fade into the Holst, and you can definitely hear the influence of it. What I could find out, and I would be curious to know if any of our learned panel would know more about this, but from what I was read, this was settled out of court. And the speculation was that there was some money paid to the Holst estate to make this go away. More recently, Hans was sued over his score to 12 Years a Slave. And apparently that case involved a person that worked for Hans who claimed that a melody he had written for the film was then used and he wasn't credited, and he filed a lawsuit. That did not go well for that composer. He lost, and I can only suspect that part of the settlement was he had to make a public statement, which he did, saying he regretted ever bringing this lawsuit against Hans, and that he was sad that he did, and he apologized. I'm sure he didn't do that out of the goodness of his heart. I suspect that he had to do that as part of the, you can either pay all my legal bills or you can issue this statement. You choose. And the person, I'm sure, chose the less expensive route. But in both of these cases, what the composer ended up with is much more effective, in my opinion. And I don't know how much legal weight that holds in a case like this. And obviously, somebody doing a local television commercial for a used car lot isn't going to get sued for this. But a big major movie like Gladiator that is produced by a major studio, that's composed by a very, very successful composer, provides enough of a target that this thing, I'm surprised it doesn't happen more often. I thought it might be fun to look at a few examples. The first series that I got hired to work on was a series called Tiny Toons. And
come and listen to a story about a man.
That is part of it, believe it or not. Part of the show was doing parodies of existing shows and movies. And it's fascinating to me, and probably if again, somebody from our panel want to talk about they had no problem doing visual parodies of well-known TV shows. But the music, which then I was hired to write a piece of music that added to that parody, I had to be very, very careful about not getting too close. And a standard clause in all composers' contracts is, and I love this word, this is a $10 legal term, folks, indemnification. I love that word. It's a standard clause in all composers' contracts that basically says, do it exactly what we want you to do, but if you get caught and you get sued, it's all on you because you've signed this contract and indemnified our legal responsibility for it. And when I was working on this show, all the composers, there were several composers who worked on this particular show, and we all thought that we were all going to go to jail at some point, because it was clear that you're doing a parody of, and in this case, I'm going to show you some examples. The only time that I know the show was sued was they tried to do a spoof of Oklahoma, the musical. And the way they did it was going to be called Ducklahoma. And what they did was they took the original songs, the Rodgers and Hammerstein songs, wrote new words to those songs, and then had the composer write a new melody with a new song, with the new lyrics that had the same rhythm, and they didn't get away with it. The Rodgers and Hammerstein estate are quite voracious in going after these sort of things, and they did get sued, and they did have to pull this from it. Fortunately, I didn't work on that episode, but I did work on 2 episodes that literally were nothing but spoofs of TV shows. So I thought I would show you what I came up with, and then obviously what the original show was. All right.
Stay tuned for the world's smartest dog, Flashy.
Over the river and through the woods to Grandmother.
Starring June Lockhart.
It's the Babsy and Bushwinkle Show.
Come and listen to my story of Montana Max, a billionaire brat wiped out by income tax. Uncle Sam come a-running out to repossess, and Monty lost it all to the IRS. Foreclosed, that is. Chapter 11, Sucking Sidewalk. Well, the next thing you know, old Monty's on the street. His ex-friend said, "Hey, move it, that beat." Said the great outdoors is the place you ought to stomp. So they lit an Acme rocket and sent him to the swamp. Possum swamp, that is. Marsupials.
Come and listen to my story about a man named Jed. A poor mountaineer barely kept his family fed. And then one day he was shooting at some food, and up through the ground come a bubbling crude oil, that is black gold, Texas tea. Well, the first thing you know, old Jed's a millionaire. The kinfolk said, "Jed, move away from there." Said, "California is a place you ought to be." So they loaded up the truck and they moved to Beverly.
So that's just a few examples of what the the gauntlet that composers and media are asked to do, and it frankly surprises me that we don't have more lawsuits in this field. But I guess it's just harder to prove than we thought. I'll just close with saying, you know, how is a filmmaker supposed to tell a composer what it is they want? Because there is no one way to score a scene. There really isn't, and so it amazes me. Back in the old days, a filmmaker didn't hear their score until they were at the scoring stage with an 80-piece orchestra playing it, and if they didn't like it, chances are they were stuck with it because the cost and the time of replacing it. You don't hear too much about scores being replaced now because composers are able to provide demos and mock-ups of the score prior to that recording session, and if changes need to be made either with who the composer is or just the approach the composer has taken, they can do that prior to the completion of it. And usually by the time it has made it through all these various stages, there's been a whole mess of people that have been examining it and saying, yeah, this is going to be fine. Anyway, I thought that they I'll just turn it now over to Judy and hear what the legal experts have to say about this.
Thank you, Mark. Just give me a moment to introduce Judith. Judith is we've been waiting and kind of saving her till next to last because she has the distinction of being the person who everybody's been worried about in the music industry, and maybe they don't have to be now, but maybe they do. One of the questions that we got, I'll just give in advance, this would come to you, Judith, when you talk, is about technology and voice recognition and the whole kind of ability nowadays with technology to be able to analyze music. And what the question was, is this going to shift things toward more blurred lines analyses and towards more agreement with the outcome in that case? So maybe if you have a chance when you're talking, you could address that. Judith, as has been introduced, is a musicologist. Specifically to our purposes, she's a forensic musicologist, and she will talk about what that involves. She's someone who has a musical background. She has a graduate degree in musicology. She has been a consultant in the music industry for many years. She is now also on the faculty as an adjunct professor at UCLA at the Herb Alpert School of Music. And for our focus, she's an ideal person to talk about what do these most recent cases that Joseph Fishman was talking about signify in terms of the direction that copyright and freedom of expression are moving. She's written numerous books about this, and she advises the central players, lawyers, film studios, music studios on all these issues. So Judith, thank you again for participating. Please proceed.
Well, thank you so much for inviting me, and I look forward to speaking to the audience and hearing their questions. And I think we're about to share the screen, so I can start. And in terms of the question that was, thank you. And in terms of the question that was just posed about technological advances and various forms of voice and other forms of recognition of audio characteristics, that won't be the focus of my time today, but maybe during the question and answer, I can respond to that. It's a topic that I speak about a lot, and in fact, even when it goes to composition of music through artificial intelligence and the intersection of that with the legal protection system. But today, we're going to really be talking about musical analysis as it applies to the copyright protection system that we have in the United States. today. So I'd like to progress and give you some examples in the moments that I have here, and then I look forward to your questions. Thank you for listening. Next slide, please. So a forensic musicologist, which is really a practical description of the work that I do, pardon me, when I'm called on by attorneys or their musical clients or their musical media companies, clients, to determine whether or not a piece of music has taken too much or not at all from another piece of music. And this is enabled by the development of in technology to compose music, to utilize other music, because the music is now digitized rather than analog in its production, and copy and distribute those copies. And that's where that intersection is of music, technology, and law. But my academic background is entirely in the field of music and musicology, excuse me, but the way in which that background has been asked to be applied by the legal system is what we're going to talk about today. Next slide, please. So from what I understand, many of you in the audience are yourselves musicians, composers, performers, and music theorists, most likely. And so these words are words that you use probably in your everyday study of music. They aren't commonplace words to people in the legal community, however, even if those lawyers do represent musical artists. Very few lawyers have the kind of background as our distinguished panel does here. And I work with lawyers of all different backgrounds. Some do have a musical background, but very few have a very technical musical background. They may have been in a band, or they enjoy music, or they played in a musical instrument. They may not have studied at the depth, the granularity and depth that those of you in the audience most likely have. And it's that granularity that a musicologist needs to bring to the analysis process in order to help judges and juries distinguish between musical copying and musical similarity due to style. And that's what we're going to talk about. And these are the tools that I normally use. Remember that in music, there are two copyrights. And today there's been a blend of discussion between the copyright for the musical composition, what you might think of as the notated score, although it could be recorded also under the law. But the musical, think of it as musicians as the musical score. That is the C in the circle copyright that protects that, what you call the underlying musical work. And that is primarily the melodic characteristics, meaning pitch plus rhythm, the harmonic characteristics of chords. If there are lyrics, the lyrics are protected, the various other musical compositional characteristics. That has nothing to do with the recording elements, which are protected by different copyright, which is a P in a circle, meaning phonorecord. And that involves production, that involves style, that involves other similarities that are often talked about, including in the blurred lines case where the word vibe was used a great deal. But that's regarding the style of the recording and the production and the musical genre that the underlying musical work is filtered into. And we're going to talk about that in a moment. Next slide. Actually, before we go to the next slide, please go back one. So the other kind of musical similarities that we talk about, normally, most cases involve the composition, as I said, and it's not a case of misappropriation of another recording, even if a recording were involved in the expression of a musical work. And that was the case in the Marvin Gaye case. That was the case in the Katy Perry case. That was the case in the Led Zeppelin case, and most of the cases we've been discussing today. These were not cases involving the lifting of the material from one previous recording into a new recording. And that practice began about 40 years ago with the popularity and increase of rap and hip hop music. Beastie Boys and others were among those the early practitioners, and there were some major cases, and that was called sampling. and it was protected in a different way. Again, the recording itself has its own set of rights. And when I am asked, or my team is asked, whether or not sampling has occurred and can we detect that, we use spectrogram analysis of the sound waves to analyze that, rather than musical, what you would think of as standard traditional musical analysis methods. And sometimes we use both. Next slide, please. These are the three areas in which I, as a musicologist, am usually asked to enter into the discussion, if you will. And some of the other speakers have referred to some of the processes. For example, preventing a dispute from ever occurring. We're often consulted by record labels, film and television and media producers before something is released. And why is that? It's because there's a musical component to it that is feared by some of the parties involved to be too similar to a previous musical work. And we'll talk a little bit about why that is. But as my previous speakers have alluded to, this could be because a composer was actually hired to write something that sounded like something else. So we're often asked to do a preventive comparison to determine if the musical elements that a later work that's about to be released, for example, in a movie, is too close to the reference work. And if so, how? And then often we're asked to evaluate and make recommendations of changes. So say that it goes forward and there's some composer from a previous era who feels that his or her song has been copied, or his or her musical work has been copied without any credit and without any permission. And that's the beginning of what you would think of as a dispute. And that's what happened in the Ed Sheeran case, I'm sure, and Katy Perry case, and the recent Dua Lipa cases, and many others. There's an artist who believes that his or her work, or a portion of that work, was copied unfairly and in violation of the copyright protection elements of the composition. And we're asked to analyze that at that early stage, sometimes for the potential defending artist who feels unfairly accused, and sometimes for the accusing artist. I've been consulted on these. I mean, most of the cases are in the popular genre where most of the money is made in the music industry, but I've been consulted on cases involving Igor Stravinsky's Rite of Spring against Disney. I was actually testified for the estate of Igor Stravinsky, and Duke Ellington had a case in which he was accused of copying or utilizing portions of a collaborator without attribution and financial remuneration. And Bob Marley and many others, and it goes on. Most of those cases don't receive the notoriety that Blurred Lines did, but it's basically this comparison process utilizing the knowledge that music theory and musicology study brings to it, and applying it to these particular elements involved in musical copyright protection. And the reason why we're brought in before a dispute is about to start is because an attorney, for example, will want to know if it's a strong case or a weak case. And we often assess it and make a comment about, these are two works that are similar. However, they're both based on these building blocks that you heard Joe Fishman mention, for example, in the Katy Perry case, and many others of my joint speakers today who speak about the commonality of shared alternating commonplace chords. So we're asked to not just find similarity, but is it similarity that will stand up in court or be thrown out? If it proceeds beyond that and we end up in a trial, then the expert witness's job is really to act as an educator for the judge and the jury. For example, in the California courts, there's a requirement that there's a two-pronged requirement. One is called the extrinsic test, which is the expert's opinion in objective comparison of the musical works involved. But there's the intrinsic test. In other words, the jury is considered the lay listener, your average person, and can they perceive the similarities or the differences? And if so, in the end, the juries are in fact the ones to make the decision. And in the Marvin Gaye case, they decide in favor of Marvin Gaye's song initially to the tune of $7.3 million, which was then reduced later due to one of the participants in the Blurred Lines recording who wasn't considered a co-creator. Next slide, please. So we have only a few minutes today, but I will focus on this case because it was a milestone case. For those of you in the audience who are musicians, you may be surprised to know that the jury was not permitted to hear the entirety of Marvin Gaye's song, which was called Got to Give It Up. They were permitted to hear the entirety of the Blurred Lines song, which was the biggest selling song in 2014. It made about $16 million by that time, produced by Pharrell Williams and sung by Robin Thicke. And that was because of a unique element in the copyright law in which Marvin Gaye's music and his song was written 1 year before recordings were accepted as that tangible tangible embedding of the creative musical work, as Professor Fishman has spoken to you, so that all that Marvin Gaye's music copyright covered for the purposes of this lawsuit was not the recording at all of his own work, but only a lead sheet, which those of you who notate music know is basically a skeletal representation of some of the primary elements, but not the entirety of a musical work. Next slide. So we're going to hear a moment of each song. I will give you a kind of preview. At the ending of this, I will tell you that this case was not about cowbells. It was not about vibes at all. It was about musical compositional elements. But this is actually Marvin Gaye's recording for a moment, and then Blurred Lines. Now, the jury wasn't permitted to hear the full recording, but this is really where it started.
Everybody get up.
So you can hear, you may have different opinions about the resemblance between these, but again, my job was to dissect and determine whether or not these were similar or not. And I was given the recordings originally because it was not until almost a year and a half into the trial preparation process that the other side was able to get the judge to bar the recording of Marvin Gaye's song. So it started with the recordings, and I was approached by the lawyers for the Marvin Gaye estate for an opinion as to whether or not, objectively speaking, these two songs resembled one another. And that's where my analysis began, by listening, as I showed you in the toolbox, listening, transcribing, starting to compare various musical elements that I heard. And first I noticed the similar vibe. I noticed the similar cowbells and all. But when those were analyzed carefully, I saw that the cowbells, while they both existed, did not play the same rhythm. So they weren't playing the same material. So that is not what I focused on, for example. And the fact that both had a similar style, yes, that was true in the recordings. But I was looking at the underlying music. And here's what I'm going to show you a little bit of what the jury heard. It was a long trial and many, many hours of testimony. I'm going to just show you the highlights today. Next slide. So this is the first page of the deposit copy, which is the lead sheet that Marvin Gaye's publisher submitted to the United States Copyright Office to obtain copyright protection, forgot to give it up. This was a time in 1978 when he did this. If he had done it in 1979, I believe it, no, I'm sorry, he had done it in 1977, excuse me. He had submitted this for copyright protection. And those of you who read music can see that there's only one stave of music per line. In other words, the first 8 bars are just the bass line alone. You don't hear any of the other sounds that you just heard on the audio that I played for you. And there are chord symbols above it. And when the vocal line comes in, you see the lyrics and you see just the vocal line. You don't see the support instruments and all. This isn't a full score that you would see, when you're conducting Wagner. This is what was submitted to copyright protect this work. And the recording itself wasn't accepted as a form of the fixation of this work from a standpoint of the Copyright Office. But 1 year later, the law changed to allow recordings to represent the entirety of the composition. So this case would have been completely different if 1 year later, Marvin Gaye's publisher has submitted his song. But that wasn't the case here. Next slide. So from the outset, the biggest challenge for me as a musicologist was to help the jury and the judge understand what the musical similarities were when we were barred from including a recording in court. And I've been testifying in cases like this for about 25 years, and there has never been a single case, or am I aware of any others that I wasn't involved in, where a recording was excluded when the recording existed, especially when the recording artist was in fact the composer. So this was a challenge, and eventually, I think days before the trial, we were successful in having the judge allow us to create our own recordings that we could play for the jury in short excerpts, as long as those recordings did not include a single note or element that was excluded from the lead sheet. So we basically were allowed to create a stripped down version of this. Now, before the recording was excluded, this case was going on for about 1.5 years. It started in 2013, and the trial was almost 1.5 years later. The first time I was asked to analyze it, the recording wasn't yet excluded. So I found the similarities going throughout the entire body of blurred lines in an unusual design fashion, which I described as a constellation of similar features, that each song had a similar intersecting and impactful series of similarities, but not in a straight linear way. So you'd see one bar that had similarities 1, 2, and 3, another bar that had similarities 4, 5, and 6, and it would move around like that. And I'm going to show you a few of those. But in general, I found a constellation of about 16 similarities, including some of the recording and production elements. And one of the big ones was, I called it the woo, W-O-O, because I noticed that on every other bar throughout Robin Thicke's song, on the second half of the third beat, which is, most of you know, is a weak part of the beat of a 4-beat bar, there was a calling out of this word woo at a high pitch. And I noticed that Marvin Gaye's song also had a woo called out at a high pitch, also on the same exact rhythmic position. And so in Robin Thicke's song, it occurs 62 times in his entire song, which meant that every other bar for the entire song, which was over 100 bars long, this element occurred, and it was directly linked to Marvin Gaye's use of it. But that was only shown in the recording. It wasn't on the lead sheet. That was one of the many other similarities that had to be eliminated from the trial. And so the jury never heard about that woo, so to speak. And there were others like that. So we were restricted down to about half the number of similarities we found, which we ended up in 8 similarities. And those are the similarities I testified about, but they are compositional, they are melodic and rhythmic, and various and structural and other elements of a musical composition. They are not style, they are not the beat or the genre, because again, the jury didn't hear the entirety of Marvin Gaye's song, so they couldn't determine what the song felt like. Talking about something in the beat, the vibe and the beat and all is talking about sort of the impact on the listener. This was not about that. I was allowed, here are two examples that I was allowed to bring to the trial. The first is from Marvin Gaye's song, in which you'll see the interaction of the keyboard and the bass playing similar target notes and the two alternating similar chords on the same offbeats in each case. And this was considered what I called the heartbeat of each song. And this continued throughout the entirety of both songs. So the jury did hear this, for example, but they heard it in isolation. They didn't hear the entirety of the song that went with this or the vocal lines above it or anything. This is one of the exhibit pieces from the trial. I was also allowed to play the keyboard in the courtroom, though, to help the jury understand the musical context, but no recording was permitted. Next slide. So another similarity that I found, because really the musicologist's job is to dissect and really drill underneath that hood and find out what makes each song tick, if you will, and where the similarities are. And what I did find is that Marvin Gaye used the technique of word painting. And although that's commonplace in those of you who study, Renaissance music and other forms of music that use word painting to illustrate musically what the lyrics are singing or speaking about. And you've all seen it in various forms of music, including religious music. And as the lyrics talk about ascending to heaven, the melodic pitches may rise higher and higher to illustrate that musically, or lower and lower if it talks about descending to Hades, for example. But in Marvin Gaye's era, that wasn't common for popular music to do. But Marvin Gaye did do that with 3 phrases one time in his song. And these phrases were the set of lyrics: move it up, turn it round, shake it down. And he did that with similar pitches and melodically illustrating it similarly to the other song. The other song did it in a different order, but it also had 3 groups of lyrics similarly worded, as you can see here: shake, round, get down, get up. And when it did those action words or those descriptive words like up, down, round, it used a lot of the same target pitches. And I was allowed to talk about this in the trial. Here's an example. I created a bit of a mock-up of this particular exhibit for you. Next slide. And you'll hear, if you listen closely, an alternation, a mashup, basically. First, you'll hear Marvin Gaye, and then you'll hear what I thought of as similarity to the point of copying of Robin Thicke singing, and it'll go back and forth 3 times. So please listen.
Move it up, get up, turn it round, shake it round, ooh, shake it down, get down.
Thank you. Now, what was interesting, next slide, what was interesting about this is that the location of the word painting, which occurred only once in each song, was also important because of this. The word painting formed a bridge in each song to an area that was a deviation in each song. So we have a similarity in pitch, we have a similarity in lyrics, a similarity in technique, and a similarity in function. So they formed a bridge. In Marvin Gaye's song, it was right before a section called the parlando section. And in the other song, it was immediately after a deviation which was a rap section. And in both cases, they formed a bookend amongst with this deviation section. And this was key in the trial, and I was allowed to show this because it was shown on the lead sheet of Marvin Gaye's song. So Marvin Gaye, as you may know if you've heard his music, had a very wide vocal range of, close to 3 octaves, and he would show that in his writing and his singing, and in fact his song Got to Give It Up shows him in his falsetto and down in his lower register, etc. And he was really very, very talented as a singer, and he wrote melodies to enable him to display that. But at one point in his song, he stops that kind of singing and sings in more of a monotone and in more of a spoken chanting way. And those of you who studied opera and other forms of concert music have heard this term parlando, which basically describes half singing, half speaking. And he did that, and it was unusual because it changed the nature of the vocal line entirely, and it went on for 15 bars. And then he went right back to his original style of singing and his original musical composition that we had heard up to that point. And he never did it again in his song. What was really stunning was that on the Blurred Lines song, there was also a complete deviation with a guest rapper who was brought in to do a spoken section. Now that's very common in the day that Blurred Lines was written. But what was really noticeable, and the rapper whose name was T.I., was that this one-time deviation occurred exactly in the same bar as the parlando section did in Marvin Gaye's. And it went on for 15 bars, just like Marvin Gaye's did. And then it ended and led to the word painting, where it resumed its ordinary melodic style and went back to Robin Thicke, in fact, changed performers. So it was the location and the structure, and on the recordings, because originally the recordings were permitted early in the case, it was down to the identical millisecond beginning and ending of parlando and rap. And to me, this was like a fingerprint, at the scene of a crime. And in fact, it was said that it was basically that Pharrell Williams used the template of Marvin Gaye's song to build his song. And that's why we saw the similarities in a constellation kind of throughout the entirety of Blurred Lines, and not just an isolated one similar melody and one similar instrument. Next slide. So the challenge for me as a musicologist was how to communicate this to a jury of people who have no musical training. They were selected because they didn't have musical training in terms of the decisions of the lawyers who were selecting the jurors, for example. How would they retain this information from these little snippets and some of the keyboard illustrations I was permitted to do? And also, they don't look at a sheet of music like a lead sheet and hear musical sounds in their mind. That's takes years and years of musical training, as all of you know. So I had to devise, really, it was a challenge to devise something that would educate them and they could retain. And I felt that visually people can retain information more if they're average people and not trained musicians than what they hear only. And so I created a roadmap of Blurred Lines, the song itself. And for those of you who know music, you'll see that it's divided into 2 halves. The upper half, it's separated by the horizontal black line, which basically summarizes what bars have similar music. And if you look at this, this is the constellation of the 8 similarities we were permitted to describe to the jury. This doesn't include the woo and some of the other things, but it does show the parlando and the rap, and that they are exactly in the same place. If you look down at the lower half, you'll see the aqua showing maybe Yasmin can circle that for me, but I'm sorry. So the aqua is Marvin Gaye's parlando section, and right below it is the equivalent rap section from Blurred Lines. And you can see that they're located in the exact same bar, and all of the other colored horizontal lines represent the elements that were similar and what bars they took place in. For example, the keyboard parts, which is in the center and is shown in beige, you can see that it's in most places. Whenever there's whiteness, that means that in that particular beat or that particular bar, full bar, it wasn't there. It didn't exist in blurred lines at all. But you see how it's paired with the green line above it, which is the bass where I played for you originally, that they have a way of driving the song forward. And so the middle line, which is the black thick line, shows where it's called composite of similarities. And the idea is that if there's at least one similarity in that bar, that black line will be shown. And as you can see, it only breaks a few places where there's a bar missing any similarities. But the majority, this represents over 130 bars of music from blurred lines, and it shows that the greater percentage of blurred lines contain multiple features from this constellation, as in Marvin Gaye's song. And this was shown to the jury more than once. Next slide. So I know we're running low on time. As I said in the beginning, here's what the case wasn't about. Despite the years and years of scholarly work, but also journalism within the music industry and entertainment industries and legal areas, there were talks about this case being bad for music creativity, and that Marvin Gaye was trying to monopolize an entire genre or a vibe. And that may be true, that the style did resemble Marvin Gaye's, and actually Pharrell Williams was seen on shows like Oprah saying he did want to reproduce the style of Marvin Gaye, and that this is actually his favorite Marvin Gaye song. But that wasn't what the analysis was about, because we weren't even allowed to play the recording that might have conveyed that. It was really about the composition, and it wasn't about the feel. That may be what created the perception of similarity, but it actually wasn't what the law addressed at all. This was pretty classic copyright infringement case. Next slide. So we're running low on time. For those of you who do musical analysis, I've devised what I call a hierarchy of musical elements that I look at when I'm assessing musical similarities. I know that Joe spoke about, the emphasis on melody. Melody is comprised of pitch plus rhythm, meaning duration, as you know. But these are the elements that I first look at, and music that lacks melody, such as spoken music that has rhythm but no pitch, then we focus on elements that are actually there. And it varies. And I feel like as musicians, I don't have to spend too much time on this, but this is the way I filter down and compare music and develop criteria for whether or not the similarities are musically and legally important in this case. Next slide. And these are the kinds of distinctions that a forensic musicologist like myself is expected to apply to that intersection of music law and technology, such as idea versus musical expression. Ideas are not copyright protected. So the concept of two country western songs singing about, a boyfriend leaving you at the altar, that's not protected, but the actual expression of that storyline, such as the names of the characters the song sings about, or the specific series of lyrics that describe it, that would be the expression. So it's up to the musicologist to filter out just simply ideas and focus on the way in which the musical ideas are expressed. And the same is true of genre. You've got 5 billion songs written in a particular genre that sound like one another because of their shared traits, but those traits are not necessarily the compositional traits that are covered by the law. And so it's really that the job of the musicologist is to make these kinds of distinctions and to help attorneys and their artist clients determine whether or not this is legitimate if they proceed. Next slide. And just to touch on for a moment how sometimes this happens, it usually doesn't happen that there's a copyright infringement claim. It usually happens not because of coincidence, but because something generated the similarity. And we've already heard a wonderful display of what happens with film scores, and I'll just end with that if we could for a moment. So, I mean, here's an example. Well, next slide, please. So as other speakers have mentioned, there's no bright line. There's no, you can write, if you copy only 6 notes, you're fine. But if you get to 7, you've got a problem, etc. Or 14. I get calls all the time from people who say, is it okay to copy 14 notes? So these are all the myths that people sometimes bring into their work as creators of music who are concerned about accusations. And I would just tell you that basically there is no bright line. And it's really much more granular than that. Next slide. A temp track is the part of the reason why these things happen, as we talked about it. And we're running low on time, but if, for example, if one were to hear the Superman theme by John Williams and be assigned by, say, an indie film director who is is directing a movie about a superhero, he or she may say to a young composer, write something that sounds like this, but don't get too close. And that's where a lot of the problems come in, because of course that's in the composer's mind, and whatever the similarities are melodically and harmonically and in other stylistic ways that sometimes do become an issue and make it sound like the earlier referenced work, that's dangerous. Next slide. So thank you. You can close it. Here's how you can reach me if you have questions that arise later. But thank you very much for your attention. And I think you can take that slide down. And I look forward to hearing from the audience.
Okay.
Let me just ask you the one question I started with, now that you've concluded. And this came from a friend of mine who is a computer person, a tech person. How will new computer pattern recognition software affect litigation? The amazing developments in speech recognition depend upon computer algorithms zooming among levels of detail to identify similarities. Will these tools shift the argument more in the direction of blurred lines? You've talked a bit about that, but maybe you could elaborate.
Thank you. Yeah, certainly technological developments do allow for certain kinds of recognition of recorded sound. And speech recognition technology and all was, I believe, developed originally by the FBI. And actually, we used this in one case involving Julio Iglesias. But basically, we're taught that's the sound, the P in the circle copyright. In other words, I'm not aware of anything that has a sophistication or a nuance ability to analyze a musical composition on the level of granularity that would be needed for a copyright infringement action. It could be developed eventually, but it's usually built on observational elements of a pre-existing recording and the patterns that it recognizes. And that's what leads to machine learning and artificial intelligence music composition. But I don't know, I mean, it may be used as a tool as it becomes more and more nuanced in recognizing similarities, but mostly in my experience so far, it recognizes similarities of recordings. So it can clock, the beats per minute or many, many other elements, or the number of pitches and the various sound waves and all. But I don't see anything so far that's useful in music analysis from a compositional standpoint.
Yeah, I had a couple of procedural questions. Would that be okay to ask that?
Absolutely.
And again, this probably shows my inexperience with this, but and you might have said it already, but the two questions that came to my mind is that the primary listeners of all this music are using their ears. So why not the oral comparison? And then the second part of the question is, in terms of the voir dire, why not have a jury of peers who had musical ears?
Yeah, you want me to answer that? Or at least in my experience, Daniel?
Yeah, I think both you and maybe Joe also would have a comment. Go ahead, Judith.
Oh, thank you. Well, I've been in the jury selection process with litigators at the beginning of trials, for example. And my experience, I mean, I'm not a lawyer, but my experience in watching that process and often being asked to opine on the qualifications of a potential juror, are that lawyers do not want one particular juror to influence and lead all the rest. So for example, I was in a case with some very well-known artists involved, and the attorney, there was a possibility of choosing a juror who actually taught at Juilliard and had a great, musical background. And the attorneys couldn't get that person out of the room fast enough, on both sides, by the way. No, neither side wanted somebody that knowledgeable. And what was kind of interesting in Blurred Lines, because I was also in that jury selection process, was that one of the jurors was actually a DJ. And, the judge was really strict about not exposing the jury to the full scale Marvin Gaye recording. And he would say at the end of every day of this long trial, the jurors were not sequestered. They could go home. So he'd turn to them and say, "Thank you for your service. Please do not go home and listen to Marvin Gaye's song." I don't know what they did when they left, but I'm saying, like, it was really, really strict. He didn't want them to sort of self-educate. He wanted them to stay very sort of pure in the trial. So I'd say the danger seems to be that, you may have a kind of armchair, one person who seems to know more than the others. And I think it influences the jurors too much. But
I was just thinking about it in terms of the level of comprehension. If you were doing the same thing with a storyteller, it wasn't written down, but there were two storytellers. People speak English at such a level that they'd be able to be discriminating listeners as compared to whatever the jury was who was deciding. Again, I don't have an answer. I'm curious about that. It's just very fascinating to me.
Well, as a person who's obviously a very accomplished educator and scholar yourself, I can see that. I mean, how hard it is to teach even a trained musician to isolate something. I mean, a recording might have 15 things going on at the same time, especially in popular music or orchestral music for that matter, much more than 15 things. And you're trying to talk about that one flute melody, or that one vocal line, not the backup group. How do you teach a person with no musical training to do that? And that's really the challenge.
So I do have a thought on this. And there is nothing in the Copyright Act, there's nothing in the statute that would prevent us from having exactly the system that Chris is envisioning, where the decision makers have musical training that would enable them to be informed consumers of the kind of work product that Judith is making. But courts decided about 75 years ago that a copyright is an economic right. It's meant for the marketplace. And so the decision makers should be channeling the perspective of just your average listener who has no particular training. And courts, the judges didn't need to make that decision. There was nothing forcing their hand to do it. Congress didn't tell them to do it. Congress said nothing on the matter, but that's what they decided in the 40s. That's where we are still now. And if there's one line that if you'll indulge me, I just need to read from a case called Arnstein v. Porter. The Porter there is Cole Porter. And there's a hugely influential case from 1946 where the appellate judges said, the impression made on the refined ears of musical experts or their views as to the musical excellence of plaintiffs' or defendants' works are utterly immaterial on the issue of misappropriation. For the views of such persons are caviar to the general, and plaintiffs' and defendants' compositions are not caviar. So, I think there's like some layer of elitism that is underwriting all of this, but that the path dependency since then, that's what happened in the 40s, and we've just been chugging along with this system ever since.
Thank you. That's really informative.
Yeah.
Okay.
We'd like to move next to Ari Sokolov, who is an entertainment lawyer. He teaches also at Eastman in the areas of law and business for composers, performers, music educators, and the like. He has a fascinating background. He has a degree from Berkeley in classical languages, I believe Greek and Latin, and somehow or another that led him into music administration. He became the executive director of the Portland, Maine Symphony, followed that by becoming executive vice president of the Philadelphia Orchestra when I think they were either in Chapter 11 bankruptcy or on the verge of it, and had to work guiding them through that. He also then went back to Maine, and about roughly 10 years ago, decided that getting a law degree would be helpful for him in terms of what he could bring to the music industry. And he did, and has been a lawyer now, and originally with a firm. Now he has his own firm that I think it's fair to say specializes in representing artists, not necessarily musical artists, but people who are involved in the arts and need counsel that's particularly knowledgeable about that. So he's a perfect person, I think, to sum up for us how the practical practitioner who has clients who come to him or her and want to know, I've got this composition, what do I have to think about in terms of whether I can just record it and or file it with the Copyright Office? How do I do that? How do I protect myself? And then secondly, what do I need to think about in terms of the possibility that somebody's going to make a claim that I'm infringing on their rights? I mentioned one last thing that I read about it, an article about Ari that totally captured me, but not necessarily his most important bio achievement. He played oboe in the San Francisco Youth Orchestra, and including a performance they did of Peter and the Wolf. You may remember the oboe is the duck. And the narrator was Sharon Stone, who was actually once a client of mine on a matter. And I don't know how you paid attention to playing the oboe, but I would have loved to have been there to have heard that. So Ari, please proceed.
Well, thank you so much, Dan. First of all, it's so great to be here. I actually feel like I just went through a master class myself in copyright law and musicology and musicological analysis, and also just getting to know, as Chris started us off with, just music, because this is all about music at the end of the day. And the fact that we started there, I think, was a brilliant way to bring the conversation together. And I think that's what we all share in common, including everybody who is, I would imagine, joined us as participants. So I think I'll just add a few punctuating remarks at this point. The first thing is, being that I'm here in Maine, I think this may be the closest I will ever come to the blurred lines case through Judith's participation in this panel. And it's just really such an honor to be able to be here with you to hear about that particular case from the inside. And I really feel like we have heard something, just brilliant in terms of understanding all the work that goes into putting a case like that together. So thank you, Judith, and to all the panelists here. Professor Fishman kicked us off with, as well, I think, a really excellent summary of music copyright law. And we've been talking about the two sides of a music copyright. And I think I would just add to that by saying, what you see with Professor Azera and Professor Waters is that every aspect of what happens here is just so highly professionalized. And so there's such depth to trying a music copyright case. It's not something, I'm a transactional entertainment lawyer, I wouldn't even attempt it because of the degree of knowledge, experience, expertise involved in understanding courtroom procedure, in understanding issues around jury selection, understanding how to work with experts. All of those things are just really highly developed skills. And I think we lose some of that sometimes in the kind of broad headlines that we see, so-and-so has been sued, and we just sort of assume that it's like a a one and done exercise. The headline's been printed, and the celebrity musician has been named, and we all think that narrates the story, as it were. But there's so much, and I think one of the things that I really enjoy about teaching this material to composers and artists and future musicians, including everybody at Eastman, is the sort of takeaway that happens when you start peeling the layers and seeing that actually there's a tremendous amount of complexity here. There are many blurred lines. There are many ambiguities. There are many inconsistencies that exist in the copyright law and how it's interpreted. I love that slide that Judith put up around music technology and law, because that really is sort of the synthesis of how all these things come together, including in the Boozy and Hawks case with Stravinsky about new uses. I mean, that was all about foreign use of a rights that Stravinsky had granted in the early 1920s to use that wasn't even contemplated at the time, which was video discs. So that's what I love about how this evolves, and it's a lot of what I talk about with students and with clients. So I thought we might actually start. I'm going to kind of go back and forth here between slides. I was thinking about the preparation for today, and I want to go back to a frame that Chris presented at the beginning. And if we could pull up the first slide of the PowerPoint, and it has to do with Zoom, and not the Zoom that we're on, but the Zoom lens that we carry in looking at what's going on. And so I started to think about this, and I use this graph, which is actually made for this presentation today. I use the graph as it relates to the recorded music industry for teaching, because it really tells the story. I think this is something that Chris was talking about as well, which is like, this is the story of the music industry of the last 20 years. It was, at its peak in 2001 when I was working at Tower Records in the classical music CD section in Berkeley, selling as many CDs as we could, and then it dropped off, down into the 2010-2011 period. Spotify, launched in the United States in July of 2011. And here we are. It's 2020, 2021, and I would suspect that by this year we may actually, meet or possibly succeed or exceed the global music recorded revenue total that it was back in 2001. So this is just, mind blowing when you sort of think about the overall story of the music industry, and what does that mean in terms of so many aspects of money flowing in. Artists having more capacity to hire lawyers, to pursue cases. And I think importantly, this was the lens that I sort of I was curious about. And then when I looked at it, it kind of confirmed my suspicion, which is I went and looked at the GW Law blog, the George Washington University Law blog, where you can go and find a listing of music copyright infringement cases over the last 150 years. And I just went through and identified the number of cases that had been reported on that blog in each year, and only in the United States. And sure enough, there's this tremendous uptick of cases that follow, whether this is causation, correlation. I don't know that it really matters for purposes of this discussion, other than to say that when you have that many more lawyers and artists and songwriters who have essentially sort of commoditized access to music, it just changes the dynamic and the ability to potentially discover music that one might consider to be infringing. And I just think I talk a lot about that with clients, where I say something like, if this were 2001 and you made a musical arrangement of somebody else's work and you performed it locally, and it was never recorded and you never publicized, that it was the music of the Beatles, who would know about it, right? But that's completely gone out the window because of the role of the internet and the ease with which technology can be used to locate potentially infringing uses of copyrights. And this is not true just in music, but it applies in photography and visual arts and literary works. It's really across the board. So so this was just sort of a fascinating lens to look at, why we're seeing or why we might be seeing some of the increase in the headlines and sort of the degree to which it dominates our thinking about use of music copyrights in day-to-day work. If you can go to the next slide, I think there's another sort of fascinating statistic, which is that the average number of songwriters has increased. Used to be, you would have just a composer, a musician, and a lyricist, and the two of them together would create a song, and that's what would, became, much of the songs of the 60s and 70s and all the way up until the 90s. And then all of a sudden something changed. And that was that the number of co-writers, who were brought in to produce a song went from 2.1 to 5.5 writers on a pop song. And so if you think about like, what does that mean in terms of just the likelihood of somebody coming into the writing room, bringing in an outside influence that, they may have encountered, you exponentially increase the possibility of that just by increasing the number of people who are participating in the co-writing process. And all of this, of course, is being dictated by song splits, that govern, the music publishing industry. Interestingly, in the early 1990s, I think there was sort of an uptick, or there was an uptick in copyright infringement lawsuits around sound recordings, as we've talked about the distinction between the two. And it just became the practice after that, if you're going to license or if you're going to sample a sound recording, unless you thought you really had a strong fair use argument, you would just go out and get a license to do so. Interestingly enough, there was a fair use case just a few years ago involving Drake and the Jimmy Smith rap, where he actually did prevail on a fair use argument in the connection with the use of the sound recording copyright. And so you can take the slide down now. I'm going to transition into just a few remarks. So I think, that Zoom really influences a lot of how, I work with songwriters and composers and clients and everybody, who's here to sort of think about like, what's the broad range within which we're operating and how much of that is dominated by pop music. I think this was said earlier, by Judith, but there's just that much more money in pop music that obviously influences the degree to which somebody can bring a claim and can defend a claim, and the amount of money at stake in connection with these royalties is substantial, and we're seeing that most recently in these multi-factor catalog sales that are happening, for these legacy artists who are essentially cashing out on their copyrights because of the increased value of music copyrights, both for licensing purposes, but also for purposes of essentially being able to take advantage of all these new technological uses. So let me just I want to sort of, for practical purposes of everyone here, I guess the thing that I advise and think about with clients more than anything is, how are you stewarding your copyrights? To me, that is the number one question, of which enforcement is just one layer in that. And I know that one of the questions that Jamal kicked us off with today was, how do you protect and maintain your copyrights? And I think a big part of that is just the process of maintaining and submitting registrations. And one of the things that I was thinking about in preparation for today's materials was this question of, have I ever had a client, or would a client ever come to me and say, I'd like to submit a copyright registration for a 5-note melody? It hasn't happened. And I wonder if it ever will happen. And to me, there's something really interesting in that from a transactional sense of, we zoom in so narrowly on, what could be an 8-note ostinato in the case of the Katy Perry case, to sort of ask, is that something that could be the subject of infringement? And in that case, the court came back and said, well, no, it wasn't protectable to begin with. And it goes back to that question in my mind of, if Katy Perry and her songwriters had come in and said, we're going to submit a registration for an 8-note, ostinato, how would I advise them? Could I even say, yeah, that's something that I think, we could submit and get an examiner to to succeed in accepting, as something sufficient for purposes of copyright registration. So there's something sort of a flip side to it that I think about in cases like this. The administration of copyrights, basically how are you as composers and songwriters just simply taking the time to identify the copyrights that you've written and to verify your ownership. That's an essential task. Clearing material that you use, licensing it for value, enforcement, which has been the subject of today's discussion, and then fair use of copyrights is a very significant question, to which we use the common phrase, it depends, and there is no black and white answer to that four-factor test. One little known area of copyright law that I think is important for everyone here to be mindful of is the termination and recapture provisions under section 203 and 304, which, if you're a work for hire composer, like Mark, may not be available to you because the law doesn't provide for termination recapture of work for hire copyrights. Whereas, if you entered into a songwriter or publishing agreement or some sort of a license or non-exclusive license, you might have that ability to reclaim your copyrights and essentially gain new value. And I think it's an increasingly important mechanism under the copyright law to be able to steward these copyright assets. Everything from purchase and sale of copyrights and catalogs to the compulsory licensing under the new Music Modernization Act. How do you as a songwriter or composer collect your mechanical royalties for all these new digital streaming uses from the Mechanical Licensing Collective? International copyright issues that come up, particularly with foreign composers. And so, what might be a use of a work that might be in the public domain in the US may not necessarily apply if it was, co-written by a foreign composer. And I've seen issues like that come up, for example, in the work of Three-Cornered Hat, Manuel de Falla, which had multiple composers that extended the life of copyright under international law. And then just generally, just copyright awareness, all the issues that we've talked about today. So at the risk of running over in time and also just being a little bit provocative here, I just want to put up 2 more slides and then we'll turn it over to the group. If you're not aware, you should be aware that there is a section of the Copyright Office website called the Compendium of Copyright Office Practices. And for composers and songwriters and anybody working in music who's really interested in learning about the basic building blocks of copyright registration and copyright practices, I would highly encourage you to go read the compendium, and particularly sections 800 as it relates to the issues involving music copyrights and performing arts copyrights, because as we talked about earlier, the essential musical elements for works of authorship are defined there. And this, I like, in terms of both Judith's hierarchy of protection and Professor Fishman's comments about the melody only standard, it's not surprising that the compendium specifically references melody, rhythm, harmony, and lyrics as the elements of a musical work. And so, whether one independently, right, could be used as the basis of a copyright claim is a different issue. But when taken in combination, those are essentially those building blocks that the Copyright Office has defined to say, you need these in order to at least state a claim for protection of musical work material. And I think, those are the essential ingredients. Okay, well, how has that played out? Last slide here, and then I'll wrap up my remarks. I started to think about this question of, is there anything about current cases that might tell us a story about what's going on? And in particular, Professor Fishman brought this up as well, which is, will judges start to play a more active role in attempting to break apart what we might call this mixed question of fact and law? And we don't have, obviously this is not a group of law students here, but I'll just say, my first year civil procedure professor would emphasize that, the role of a lawyer is to think procedurally. And, the slide that Judith put up talking about how to prevent a dispute, how to prepare for a dispute, and then how to, be at trial, is all about thinking procedurally. And what's interesting to me is that, the blurred lines case sort of fits in that, medium probability sort of yellow box of saying, well, it, very well could and should, move past summary judgment to a trier of fact on the issues of intrinsic similarity, because of the way in which all of these elements, were combined over 130 measures to create essentially the protectable material, even though taken alone, the independent elements may not have been protectable under copyright law. So I think there's something interesting in here that maybe, I'll be curious to see, particularly because I thought that the district court's opinion in the Katy Perry case, I thought that Judge Snyder, and we could take the slide down here, I thought that the judge, essentially went out of her way to give other judges a roadmap of essentially, how to take apart a music copyright infringement case, under the most recent standards that we have, where you incorporate different elements that we might hear beyond the melody only standard. So I think we've come, this is all happening in real time. For those who want to learn more about the history of this, particularly in the pop music realm, I would highly recommend John Seabrook's book, The Song Machine, which is just outstanding when it comes to kind of retelling the story of pop music over the last 25 to 30 years. And then also there's a wonderful publication called Tales from the Public Domain, out of several professors at Duke University, who wrote a history of theft and music. And it's just a really wonderful illustrative example of kind of the long history of musical borrowing in the world in which we occupy. So again, thank you for the opportunity to join the group here. And I'm going to turn it back over to Rachel and Dan at this point.
Thank you very much, Ari. What we'd like to do now, we have questions that have come in from the audience. We'll address a couple of those, and as you and the audience hear more or want to formulate questions, please send them along, and we will do our best to address all of them in the time we have remaining, which is about 20 minutes. Before we get to that, I wanted to invite our speakers to ask any questions or raise any issues that they might have with the other speakers that they'd like to explore that have come up at the presentation so far.
I'm curious for Mark, when he is making these judgment calls about what changes to make, how far to move away from a reference piece while still evoking it for listeners. Do you consult with anybody about that? Are you getting guidance from anybody, whether with legal training or not? I mean, what resources do you have to make those decisions?
I'm probably being pretty risky here, but I usually, if I'm worried about something, I may play it for a friend. Hey, does this sound too close to that? But then there's also the issue, and I'd love for clarification on this, as far as intent. In other words, if I write a piece of music that sounds like the theme from Rocky, but it's for, something has, or let's just say, I'll go the other way, if it has something to do with a movie about a boxer, and it may have a lot of the same elements in it, but not exactly the same melody, would I be susceptible to litigation? But as far as, I wish I could say that every cue is submitted to a musicologist that the studio has hired, and every cue is checked and rechecked, but it's not the case. It really isn't. I mean, I suppose that's why I was saying I'm surprised these kind of lawsuits don't happen more often than they do.
Thank you.
But I mean, can anybody answer as far as intent You know, I'm intending to write a piece of music that sounds like this famous theme from a boxing movie. Or in the case of the parodies that I did, what is the allowance for the fact that it's a parody?
I can try and answer that briefly, though this is not legal advice. Intent in the baseline question of is it infringement or not, intent is not supposed to play a role. It's supposed to be a strict, what's called a strict liability standard, where we look at what comes out of it, not what was going on in your head when you were doing it. But you know, in fair use, I was talking about purpose before in the context of educational uses. You know, swap that now for a parodic purpose, right? You're trying to make a parody. Right. Another word I think you could use for that is intent. What I was trying to do was to make a parody of this other song. That is a privileged purpose under the fair use analysis. So what you're calling intent there could come into the analysis on the fair use side.
May I add to that?
Yes, certainly.
Thank you. So I would just say that the other question is people who are sort of mostly parody artists, like Weird Al, for example, they license the works that they are creating parodies of. So that's another option. Sometimes that isn't done, like in the case of, you know, Disney and Family Guy. I don't know if you know about that case, but sometimes things go very wrong when there is a parody created and no license has been sought. But you know, but I'm just saying in some cases one sort of protects oneself by licensing it in advance.
Yeah, it's interesting. In the very famous Pretty Woman case, Acuff Rose and Two Live Crew, they actually attempted to license the material for use and were turned down. And so went ahead anyway and did it. But yes, generally the counsel is to, you know, when in doubt, get a license, because that's essentially your insurance policy to address any issue that could come up. Correct me if I'm wrong. I think it could also come up on the damages side in relation to, you know, willful infringement of a work. So it may not show up on the liability section, but certainly on the damages side.
Anyone else? We do have a number of questions from members of the audience, so I'd like to use what time we have to address as many of those as we can. Let's see, I've got 3 on my list. What about the issue of cover songs on YouTube? Are artists infringing copyright if they do not ask for permission to do these cover songs? I'm assuming he means by cover songs just performing as an artist songs that are out there that they want to cover. And the question is, can you do that? Ari?
Yeah, and this is where I will give my disclaimer that I'm not offering anybody here specific legal advice. The question of YouTube comes up a lot. As you can imagine, as many of you may know, YouTube has a content ID system. It's a fingerprinting system that identifies the works that are being ingested and uploaded to YouTube. And it essentially gives the copyright holder 3 options in connection with those works once they've been tagged. The copyright holder can either do nothing, the copyright holder can decide to monetize the video, or the copyright holder can request that it be taken down. So the danger in uploading material to YouTube, right, is you don't know ahead of time, you know, what the copyright holder has decided. And so my advice to clients is always, if you're going to upload something to YouTube that you want to live up there for an extended period of time, to go out and get a sync license so that you can you know, gain the permission to do so.
Say that again.
How would you do that, Ari? Is that practical for someone?
Oh, yeah,
answering the question?
Well, certainly, I mean, you know, thousands and thousands of videos are getting uploaded every hour to YouTube, that don't necessarily have sync licenses. They're just subject to the YouTube Content ID system. But yes, for organizations and individuals that are building a presence on YouTube, you would reach out if you're using the musical work copyright, for example, and you're going to perform it and include it in an instrumental or other presentation. You'd reach out to the music publisher to request a sync license for a 6-month term or a year term to be able to leave the material up on your particular channel. And they have the ability from the other side, to approve the use of material in connection with a particular channel.
Okay.
I think realistically, the risk, if you're just somebody that wants to upload something to YouTube, the risk that we're talking about here is that the content would be taken down, right? Not that you would, right? Unless you're worth suing, you're probably not going to get sued, but the content could be taken down. So I think those are the stakes we're talking about.
Okay.
Better you say that than me.
Again, not legal advice, but.
Next question. This involves something that is pretty common in the University of Rochester and Eastman School of Music world, use of music in film created separately by the composer. The question is, an independent short filmmaker wants to use my single. I own the master recording and the copyrights for a film festival. I would appreciate an advice on how to proceed. Also, what qualities and costs should we look for or expect from a music lawyer to write or negotiate a contract? I think he's asking, are you available for a consultation, Ari?
Well, the first thing I'll say is that Don Passman's written an excellent book. I think it's in the 10th edition now, called All You Need to Know About the Music Business. And, that's always my first, line of advice for somebody who's looking to kind of work through the process, including how to interview an entertainment lawyer if you're looking to choose one. And one of the most important issues will be, is the lawyer that you're looking for, licensed in the state in which you're operating. Even though there's federal law issues, there may be state law issues. But as it relates to the specific question here, this is also a sync license question. So sync licenses are one of the most important mechanisms for generating income on both the sound recording and musical work side. And so if somebody wants to use, or you want to use somebody's music in a film or a television advertisement, and this is, essentially what Mark, was composing for, you need to secure or generate a sync license, for that particular use. And then you would specify, the terms of compensation, how long it can be used, the types of uses, all that would be specified in the sync license itself. But yeah, I encourage everyone who's looking to, learn more to spend some time identifying prospective counsel and making sure that it's a good fit for them in terms of cost and experience.
Okay. Here is another question that's come in. Might it be possible to revise copyright law for sampling and interpolation? Oh, where did it go?
Right down here.
Oh, might it be possible to revise copyright law for sampling and interpolation so that licensing fragments of a recording or melody acts more like a compulsory for a cover song, i.e. a system with a simpler, more easily understood process, cost, and share of credits? Anybody want to tackle that?
I can if nobody else is. It's possible. It would require an act of Congress, right? So we haven't really gotten into the difference between free market negotiation and compulsory licensing so much in this discussion, but there are certain uses under the Copyright Act that are, it's basically a menu with prices set by the government. And if you want to order something off of that menu, you just go ahead and deal with the paperwork and pay who you're supposed to pay, and that's it, as opposed to needing to actually negotiate and get permission from the copyright owner. So sampling is one of the things that is still handled through free market negotiation, where you do need to bargain for it. And sure, Congress could, if it were so inclined, pass a law that added sampling to the list of things that are currently subject to compulsory licensing. The thing with sampling that makes it, I think, trickier than a lot of the other uses that are currently handled by compulsory licensing is that there's so much variability, right? The length of the sample, the prominence of the sample, the whether the use is perceived as tarnishing the original song, right? If you contrast that with something like Pandora being able to engage in webcasting, or satellite rebroadcasting, these types of things that we have under compulsory licenses currently, there's a uniformity to those types of uses that you don't have with sampling. And I could see that making it more difficult to get buy-in for creating a compulsory license. But in principle, sure, Congress could pass that law tomorrow.
Okay. Next question. What impact do you see the new copyright small claims court having? Also, well, let's deal with that question first. Anybody familiar with that new opportunity?
Go ahead, Judith.
I'm sorry, I am a little bit, if you want me to.
Sure.
Try to do my best. Yeah, so that's set up to help the kind of inequity that exists between, say, individual songwriters who may feel that a major recording artist on a big label has taken something, and you can imagine what it costs to hire a lawyer and go up against, say, Universal or Sony, or it's almost impossible, David and Goliath situation. This idea is to make it common for your kind of average musician to do that. Excuse me, but the problem that I understand in a small claims court is that the other side can opt out of this. So that, pardon me, I'm losing my voice. Maybe I should turn it over to others, but that it can be opted out of.
Okay.
And that's a weakness.
Well, we're just about out of time. So, Ari, did you have a comment?
I was just going to add, in addition to the opt-out provision, there's a cap on damages. Could be up to $15,000 or $30,000, regardless of the number of sort of infringements. And I think that may be a possible issue or deterrence from pursuing that path, because your award, may be limited by a large degree. And there will be pretty significant, as we've come to learn, evidentiary sort of, basically documentation and evidentiary issues that to go through the process to kind of make the paperwork work. But I think we'll see it launches, I think, in just a few months here. So.
Okay. One more question, and then we'll start to conclude. This member of the audience asks or says, I'm also curious about fixed media compositions that exist as a work, but also as a recording. The underlying work and the specific rendering of it into a video or audio file. How the copyright law on sound recordings relates to works that exist only as a recording, can't be performed by anyone else. Joe, you're kind of nodding your head as if that sounds like something you might have some familiarity with.
So I may not understand the question entirely, but if I'm understanding it correctly, if you have a recording of a musical work, whether that is in an audiovisual file or just a purely audio file, there are going to be those two copyrights that we talked about before that are both embodied within that recording. So you have the copyright on the musical work, and the separate copyright on the recording of that work. So if it's a computer file on your hard drive, right, an MP3, then within that computer file, you have two works potentially at issue, the musical work and the recording of that work, each of which is fixed in the same ones and zeros in that computer file. So this it could be something that trips a lot of people up if you're not used to thinking about it that way, but you can have a single object, whether it is a digital object or a physical tangible one, that embodies two separate copyrights.
Anyone else?
I would say, just to add to that, to go take a look at there's a whole section of the Compendium 800 that deals with copyright registration issues for recordings and musical works fixed in audiovisual material like a movie or some other film. So they get into exactly the questions and issues that Professor Fishman just highlighted.
Okay, I think we have run out of time. I want to again thank all of you, all the speakers who have participated. I think this has been a wonderful exposition on what it's all about. Oftentimes I say to Mark, sometimes about copyright issues, Burke Backrath got it right when he asked what's it all about, Alfie? And that's kind of the question that arose for me the first time I read about the blurred lines case, and then was talking with Mark's students. And when we talked about potential for copyright infringement, I remember one of his students, these are all people who know how to compose and know how to conduct in many cases, and are there to learn specifically from Mark how to compose for visual media. His response was, we're all doomed. We all sound like John Williams. So that's a beginning place, but you can see from this discussion, it certainly doesn't need to end there. I'd also like to cite the Eastman School, and specifically Rachel, for their interest in and the efforts they have made to help put this program together. It's been a terrific experience and very enjoyable for me. I hope also for other members of the audience and for the speakers who've gotten to know each other, who bring so much to this subject matter. So thank you again, all of you. Thank you, Eastman School. And Rachel will conclude the program.
I just want to echo Dan and say thank you to everybody who spoke today, and thank you for everyone who tuned in. This, like Ari said, has been a master class, and I've gotten to sit back and enjoy so much of this, but it's been fantastic. I look forward to doing more like this in the future. And if you have any questions, please don't hesitate to reach out to me at any time. I'm happy to funnel them to the speakers as it's appropriate, or hear your ideas and recommendations for what we might do in the future. So thanks, everyone. Have a wonderful day.
And one more thing, please do go to the Institute for Music Leadership website at the Eastman School of Music website. Very exciting stuff being done. The IML is directed by Rachel, who has a background both as an instrumentalist and also in orchestral administration and management. And students at Eastman, in addition to being trained in the traditional skills of a music school, are also being introduced to opportunities that they might not have thought of, and also skill sets, courtesy of people like Ari, who are talking to them about what to think about as they advance their own careers. So thank you again, IML and Eastman School of Music, and thank you, speakers.